All right, Ms. Rivers, you ready?
Yes.
Let's go on the record. Let's see what is the issue. It's me. In State versus Parks and Phillips, we've got our defendants here, their lawyers, our prosecutors, and the jury sent out one card, two questions, different handwriting written on different sides, but they're related. One side says, is there a reason manslaughter is not included on the felony murder, and then parentheses, criminal damage, question mark. Is there a reason manslaughter is not included on the felony murder, parentheses, criminal damage, question mark. The other side of the card says manslaughter is on the first two charges and not the third related to criminal damage. That's more of a statement, but they relate. And I called up the verdict form. That's accurate. That's actually something we had discussed because Mr. Rowe's theory of manslaughter is that the shots at the alleged shots at Mr. Parks and Mr. Phillips and presumably G were of such provoking nature that voluntary manslaughter was a necessary charge, because in reacting to that serious provocation, not in self-defense, but more in the heat of passion, they fired in the direction of those shots. And I explained that that would be to the hill, which I guess is to the right of people, and not shooting up the residence that is the subject of the criminal damage to property. In fact, the evidence showed that there were multiple shots fired at that house, but not initially, later on. And so that's why I didn't put voluntary manslaughter. We didn't include voluntary manslaughter as an option for felony murder premised on or predicated on criminal damage to property. As a recap of what our discussion was, it's not the answer to the question from the jurors. Mr. Greiner, any thoughts as to what we tell the jurors in response to this question about why manslaughter is not included on count 3?
Let me confer with my colleague.
Okay. I'll take some weight off everyone's shoulders. I think the right answer is voluntary manslaughter is not a legally appropriate outcome for count 3. Words to that effect. That's why it's not in there, because it doesn't fit. It's also not there for count 6, possession of a firearm during commission of a felony. It's not fit there. And we don't need to dive into it. That's not necessary in responding, but that's my thought.
Judge, I would agree with the court that that's maybe the best thing to just say.
Mr. Monetis?
Yes, Judge. If I remember correctly, there were 2 felony murder counts with manslaughter as options, but the criminal damage to property that listed the address did not.
Almost right. So there are 2 counts that have manslaughter. Count 1, malice murder. Guilty of murder, guilty of voluntary manslaughter, not guilty. Count 2, felony murder based on the aggravated assault, which is that's the voluntary manslaughter. It's that aggravated assault, shooting at the people we thought were shooting at us, getting those people, not getting an inanimate object, but getting these people. And so count 2, felony murder premised on aggravated assault. Again, it's guilty of felony murder, just that count, or voluntary manslaughter, or not guilty. So 2 of the counts do have manslaughter in there. It's the malice murder, where it ought to go if it's going to go anywhere, but also that first felony murder, because the shooting at someone is what Mr. Rowe articulated as that provoked by being shot at. So I'm shooting back at people who were up on the hill or wherever they were.
Yeah, the jury's question, but I guess it's making me rethink everything. So if a person dies in the course of a felony murder that was.
Hold on one second. Can you mash some button? Thank you. We were getting mood lighting and I wasn't ready for that yet.
Yeah, someone dies after you were provoked into doing a criminal damage. I don't know, Judge, I guess
Let me use a different example where I think it's clearer. It's not here. If your client had been a convicted felon, and so count 7 would be possession of a firearm by a convicted felon. There's always a felony murder premised on that. Voluntary manslaughter wouldn't fit there because you being provoked doesn't make you not a felon. The fit of passion, what you do as a result of fit of passion is try to get that. The theory here, you didn't bring up manslaughter. It was Mr. Rowe, and I'll let him speak for himself in a minute. But as he and I engaged on it, what's the basis for voluntary manslaughter in a case where it's self-defense? Because it is a lesser degree of justification, if you will, for self-defense. And he articulated, I looked it up, there are cases where it takes more to qualify for voluntary manslaughter, if you will, to have a jury say, yeah, that fits. But the provocation wasn't, I don't like how that building's looking at me. So that's how I arrived at that. Regardless, that's what the verdict form says. And we need to figure out how to help the jury navigate this.
How would those merge in the event that there's voluntary manslaughter on one felony murder, but not on another, but they involve the same course of conduct and the same death?
I don't know that they would merge. I don't know how that's going to play out. But again, thinking through the possession of a firearm by a convicted felon, I could see a voluntary and a felony murder in that scenario. Voluntary on the malice murder, but felony murder on that. And I'm guessing there's a case out there that says what to do. And I suspect what it says there is you would vacate the voluntary because that felony murder is the what would control. But I'm not asking to be quoted on that. It's a hairy area. I was really ready to not include voluntary, but that would have potentially been more problematic depending on how the case plays out.
I just want to make sure I don't waive any merger issues or any jury instruction issues. I don't know.
Okay, Mr. Rowe, your thoughts on what I tell the jury?
Judge, I think the verdict form is what it is now, so I think what your initial response to the question is sufficient.
Okay. Yes. Mr. Griner, you've had more time to think about it. Anything you want to say differently?
No, nothing different. I would just say maybe the least possible one sentence or something like that.
Right. I'm going to think through the wording, and before I write it on the card, I may need another one, but I'll write it down and read it to you all, and you can say, yep, or nope, change that.
Yes, sir.
Thank you. So what I intend to write is there is not a legal basis for that outcome for that count.
A possible legal basis. So the court's not taking any position.
I don't want to take a position. That's right. And possible, meaning under the facts of this case, or what do you mean?
I just don't want them to think legal basis. Well, that's fine.
I did say for that count. It could be everywhere else, but there's not a legal basis for that outcome for that count, which is why it's not. Because the question is, why is it not there? Because it doesn't belong there. But I didn't want. That's kind of sassy to say that. Does that work for you, Mr. Greiner?
Judge, to me, what you said 5 minutes, 10 minutes ago, manslaughter is not a legally appropriate charge for count 3. I think just kind of keeping it in layman's terms would be my preference. Legal basis, that may cause all kinds of other debate. Legal basis for that outcome, for that count. That sounds like we're all having a discussion here among lawyers.
No, I think legal basis is probably a little better because that is what it is. There's no basis in the law to have it vote that way on that count.
Right. Right. The language I had said before was something along the lines of manslaughter is not a proper outcome for that count. And that's more to what he's saying. I don't want to get into the word proper because the jury decides what's proper or not. It's a purely legal question. It was something that we discussed during jury charges and not, is the evidence there? I already found that there is some evidence. There has to be some evidence for voluntary manslaughter to be injected into the case at all. So I think I'm going to stick with there is not a legal basis for that outcome for that count. Does that work for you, Mr. Rowe? Okay. All right, so I have stapled a note card to, that was loud, to what's labeled question 2. And their question is there a reason manslaughter is not included on the felony murder criminal damage charge? Answer, there is not a legal basis for that outcome for that count. Thank you. I have a hearing now where a defendant is appearing virtually from somewhere in the Department of Corrections universe. So I need a spot at the state's table, but we don't, you all are welcome to go wherever you want, but the defendant's going to be appearing virtually and he's pro se. So I will ask, once you got that door closed, if you could get Mr. Parks and Mr. Phillips back where they need to go, and we'll bring them out when we have more. Is there, there's Dooley. Excellent. Let's spotlight that. There he is. Mr. Jordan, will you be arguing this or is Ms. McCauley handling it?
It'll be myself.
Great. Do you mind being at the, or you can use your machine or you want to be at the podium? I'm fine wherever. I just want you to be on the screen so that Mr. Harris can see you.
Yes, Your Honor, I can be at the podium.
All right. Mr. Harris, can you hear us?
Yes, I can.
Great. Well, let's get on the record. This is 06SC45519. And that case is styled State versus Randall Harris. Mr. Harris is appearing from Dooley State Prison. He represents himself now. Long ago, he was convicted of aggravated child molestation and child molestation. I think that's right.
Aggravated sexual battery.
Aggravated sexual battery. Let me get one thing on my screen so I'm speaking more knowledgeably. Right, aggravated. So this is in January of 2007. Mr. Harris was found guilty by a jury of his peers of aggravated sexual battery and child molestation. The judge at the time was Michael Johnson. I've inherited his docket, and he sentenced Mr. Harris to 20 years to serve on count 1, followed by 20 years to serve on count 2. So a total of 40 years to serve, 2 20-year sentences, one consecutive to the other. Mr. Harris filed in December of 23 a motion to modify what he termed a void sentence because that 40-year sentence did not include what the statutory law requires, which is what we call a split sentence. That some part of it needed to be probated. It can't be 40 total. It would need to be some amount of custody followed by some period of probation. Mr. Harris, I don't presume in any way to speak for you. Do you agree that that's your challenge?
Yeah, and just to add to that is that, yeah, this also falls under 171061, which is actually a mandatory minimum of 10 on the credit offense, which is a sexual aggravated battery parole issues that are applied inside my motion, using that as inclusion.
Okay, hold on one sec, Mr. Harris. The court reporter is having a little trouble hearing you, so if you'd speak more slowly. I heard you talk about 1710.6 and 6.1, and then you started talking about parole, but just walk us through that slowly.
Okay, and just it's basically, I'm challenging the fact that the sentence void as a whole, but also that should have came up parole after 10 years while I've been incarcerated, based on the sexual aggravated battery charge of 20 years. According to my sentence transcript says that I have to serve a mandatory minimum of 10 years in prison, and the rest would be parolable, but that would be in collusion with the void sentence as a whole, so where we can come to some kind of consensus to try to resolve this issue.
Well, I don't know about a consensus. It's not a negotiation here. You have made a legal argument, and I believe the state concedes that you are correct in that it was a void sentence. And so what we would be doing today, and I'm going to let Mr. Jordan make the record for the state, but they filed something that obviously hasn't gotten to you yet because they filed it today, but we'll make sure it gets to you, where they acknowledge that Judge Johnson's sentence was a void sentence. And they have proposed a way to structure a split sentence. And I'm going to hear from Mr. Jordan on that. And then I'll hear from you, Mr. Harris. I believe under the law that while I have to resentence you, I'm not able to resentence you to a harsher sentence that would violate due process for you. But I'm under no obligation to make the sentence any less harsh than the smallest change that's required, which would be to include 1 year of probation in that 40-year term. But I'll certainly hear from you, Mr. Harris, on that. Let me turn to Mr. Jordan to see the state's take on all this.
Yes, Your Honor. The state does concede that the sentence by Judge Johnson should be void. I believe that the only places that we differ from Mr. Harris is that, and Your Honor, I was literally researching this up until coming into court today. In regards to the sentence that he has, the current code very specifically says that not each charge would have to be a split sentence, but only the final consecutive charge. I do not see that particular language in the 2006 code, that it is allowable, that each sentence would have to be a split sentence, or the last sentence could just be the only split sentence. So, Your Honor, the state is conceding overall to what Mr. Harris is saying. We would just ask that on count 1, which is the aggravated sexual battery.
Which has what's the sentencing range for aggravated sexual battery as that statute existed back in 2007 when Mr. Harris was sentenced after the jury found him guilty?
It was 10 to 20, Your Honor.
10 to 20. Okay.
Yes, Your Honor. And count 2 was 5 to 20, Your Honor, from my research. So on count 1, the state would ask for 20 years to serve. And for count 2, the state would ask for 20 years to serve 19 consecutive to count 1, with the balance being probated, and that the defendant register as a sex offender in accordance with the statute, Your Honor.
Okay. That would be a condition of his probation.
Yes, Your Honor.
Okay. And my understanding is that's a mandatory condition.
That
That's
is
not
mandatory, Your Honor.
you adding new punishment. It's just if there's going to be, whether it's parolable, and Mr. Harris has a perspective on parole, or probation, and there will now be a probated portion of his sentence, he'll be required to register.
Yes, Your Honor.
Okay. Got it. Mr. Harris, tell me your thoughts about what I ought to do.
Well, I think I need a little clarification on the fact that I have pretty much served 19 years incarcerated, and the understanding right now the sentencing mandatory minimum or the amount of sentence that was required on the second, I guess a secondary offense of being 1 to 5, and I served 19 years at this point in time. That I don't quite understand the position of the courts saying, well, I understand that probation will be something that will be actually enacted right now, but we have what we call I guess the rest of the sentence is saying 1-year probation, but what about the, since it's only 1 year on these, pretty much served all the time on the first offense, which is 19 years at this point. And I guess I lost between the separation between having probation on one count and probation on the other count. And I don't know how the law actually applies at that time when it comes to that. Based on what I've heard, it's telling me that probation was provided on both sides. So with that being said, well, I can't say what the max will be on the secondary offense. What I'm hearing is it was 1 to 5, and I already served the max on the sexual aggravated battery, which pretty much, well, almost served the max, 19 years. I would like to hear the court's position on how we can probably best resolve it would work for both of us, to where since I am going to be on parole or probation in respect to that, and required to do this incidentally with the court say registry, in that regard, to try to resolve this in that way, to where I can get out, come up with parole in 2026, which would actually be right at the 20-year mark, and it would max me out on my sexual aggravated battery. And then 1 to 5, which is a secondary offense.
Where are you getting, I'm sorry to interrupt, but I'm confused with the 1 to 5. Where are you getting the 1 to 5?
I think if I heard the prosecution right, that he said that at the time, the CM, child molesting charge, was actually 1 to 5.
No, what I heard Mr. Jordan say is that it was 5 to 20. So it had a lower minimum than aggravated sexual battery, same maximum, but it was 5 to 20. And to be clear, Judge Johnson didn't exceed the maximum of either of those. He hit the maximum of both. His error, and many judges did it back in the day, is that he didn't make it a split sentence. And so you correctly identified that and filed the motion, and I am, excuse me, belatedly, and I apologize for the delay in getting to it. And the state has conceded that it needs to be a split sentence. I think I have what I need to do, but I want to make sure I give you a full chance, Mr. Harris, to speak your piece into the record, and then I can enter an amended, corrected sentence that ensures that the sentence complies with the law as it existed at that time.
Okay, and do I, if I could, I mean, I would like to refer, if you could, to your look at the reports, I guess the evidentiary issues. I know we're talking about the sentence, but look at the evidence that's been applied in this case and look at the, I guess, the physician report that actually shows that there's no physical evidence in regards to the case as a whole, just to throw it in for mitigation. That based on information that's been provided, even when we went before the Court of Appeals, my attorney at that time did not raise anything that was specific with sufficiency of evidence in this case. And then any witnesses, there will be the doctor, psychologist, and including the police department at that time when they went to court, their information has provided no evidence that actually support that there was I guess the egregiousness of how the state moved forward with this case. So I would ask that in litigation, as we move forward with the void sentencing, that the court would actually use that to tend to what position do you correct the sentence.
Can you repeat that last part, please?
That the courts, I will feel be in the best of interest that the court, if they could on their side, take the time to look at the evidentiary issues and use that as mitigation in regards to how you apply the new sentence, being that the sentence is void for its mitigation. Okay,
I understand your request. It's to look at the record that was made during trial, since you are being resentenced. There was an error in your sentence, and you're saying, in thinking about that record, I might want to think about a sentence that's lower than the one that the state is asking for.
That's exactly what I'm saying. I think when you look at the evidentiary issues and mitigation, is one report. I don't have the report with me right now, but if you need me, I can actually send you a copy of it. If, of course, you guys probably already have it, I can send you an original copy of the medical report in this case that actually shows insufficient evidence to actually support the thing, and I was asking the court to use that as a mitigation in this new sentencing.
Okay. Well, I will look into the docket and see what I find there. Most of all, I do owe you an amended sentence. You were appropriately persistent in saying, hey, I filed this motion and someone needs to deal with it. I appreciate that. I also appreciate the state looking at this and not fighting a useless fight. The sentence was incorrect and it needs to be fixed, and I will certainly do that. Mr. Jordan, do you have anything else from the state?
Nothing further from the state, Your Honor.
All right, Mr. Harris, anything else from Dooley?
Yeah, just send me a transcript of everything that's of this proceeding, and I understand that you already mailed out the documents with regards to what the void sentence ruling was. I respect that, but and also there's whatever applicable to what we have going on right now for resentencing.
All right, sounds like a plan. Thank you, Mr. Harris. Thank you, Dooley, for connecting Mr. Harris to us.
And thank you.
You're welcome.
All right, bye-bye.
Bye.
All right, appreciate your time.
Thank you very much, Your Honor.
I will work with Ms. Nelson and we'll mail some stuff off to Mr. Harris.
Your Honor, if I may, I know that the pretrial conference is on tomorrow. On Mr. Kadir Wright, I know Ms. Lee previously had stated that she may be going on leave because her wife is pregnant. I haven't heard from her. I know that we were very close to a non-negotiated plea to present before Your Honor.
Right.
When Mr. Wright showed up very late for court.
Right.
But unfortunately, I don't have a further announcement on that.
Okay.
But the state will be ready if reached.
Great. Thank you.
Thank you, Your Honor.
Ms. Nelson, will this Zoom stay open for a while? Oh, she dropped off. Let me ask it this way. Yes. Okay, great. Okay, let's go back on the record in the usual State versus Parks and Phillips. We've got our defendants, our defense attorneys, and our prosecutors. Two more questions from the jury. Thank you, Mr. Rowe. The first is, if we decide manslaughter on either count 1 or 2, we must choose manslaughter for both counts 1 or 2. The other one says, does party to a crime supersede manslaughter? For a case that has no manslaughter in it, boy, we've taken up a lot of time worrying about manslaughter, but that's what a good defense attorney is supposed to do. The jurors are clearly confused. So if we decide manslaughter on either count 1 or 2, we must choose manslaughter for both counts 1 and 2, which I take to mean must we. So I don't believe it's an assertion since they gave it to Deputy Gordon to give to us. And then, does party to a crime supersede manslaughter? I'm pulling up the verdict form so I can, whoops, that wasn't it. So I'm thinking out loud as to this count 1 or 2 manslaughter. I think the answer is yes. If the jury were to find that the malice murder were in, not that it's justified, but it needs to be reduced to voluntary because of this irresistible passion that overtook one or both of the defendants, then the aggravated assault, that is the killing of the deceased, is what was the product of that irresistible passion. And so that would mean it would be voluntary for count 2 as well. So it would be an inconsistent verdict to say guilty of malice murder, but guilty of voluntary manslaughter for the felony murder, or vice versa, I think. But we have moved into uncharted territory here for me. And I don't know how to answer this thing about superseding. I may need to write to them, I don't understand your question, and let them flesh it out. But I'm going to open it up. I'm going to start with Mr. Rowe as the author of our voluntary manslaughter struggles. What is your thought about if they decide manslaughter on either malice murder or felony murder based on aggravated assault? Do they necessarily then, are they saying basically it's manslaughter for both?
I think legally I would say yes, but I'm trying to decide if we could even tell them that. I mean, I would say my first response would be.
I see your point. I think I'm agreeing with you. I think legally the answer is it's got to be both. It's either neither or both. But
I don't know if we could tell them that though.
Well, we could agree to, if everyone agrees to tell them, we could tell them, here's how you make scrambled eggs. It's a question of whether everyone thinks it's in their party's best interest. I'm a big fan of reducing confusion, but that's not always in the defendant's best interest. I don't know how this would help a defendant because it could result in a malice murder and then a voluntary for felony murder or vice versa. I think what that would result in, though, is when the jury's out of the room, we have to fix it. Not that they have to deliberate more, it would just be the way these inconsistent verdicts work is that the one that they said was murder has to be reduced to voluntary because they already found voluntary. I just soon avoid that kind of confusion, but that's an independent decision for each of the three actors here. Mr. Menendez, your thoughts about that manslaughter question?
Yeah, I agree with the thoughts of the court and Mr. Rowe. And then as far as the second question.
Well, before we get to the second question about superseding, Mr. Rowe said, I think legally the answer is yes, but maybe that's not what we tell the jury. And I'm going to circle back to him. He's going to better think about it a little bit more. Is it your view? It sounds like it's your view legally, both would have to be voluntary or it would be felony murder and murder. And yes, we ought to tell them that so they don't labor under that confusion. Or no, don't tell them and we clean up the mess afterwards.
I'm all about avoiding a mess. I've always wanted the judge to just answer the question if there's a legal answer, which there seems to be.
Okay, let's see what the state says, and then we'll come back to the superseding question. Mr. Greiner?
You know, Judge, I think that the court's instruction last week was probably best, and that is that, you know, the jury needs to render a verdict as to each defendant, as to each count. And although we may have to discuss, you know, inconsistent verdicts when the dust settles and the jury's all gone home, or we may have to deal with that, you know, just the lawyers, you know, I don't know that we're going to do anybody any favors by telling them that, because I mean, they need to be deciding this case, each count as to each defendant. And if we start trying to tamper with that, I'm afraid that may cause problems that we can't even think of right now.
Clearly, because I'm still trying to figure out the answer to the second question of this batch. And I think that's some of what you may be alluding to and what they're wrestling with is that maybe for one defendant, they're thinking manslaughter might fit, but if you're party to the crime, then manslaughter doesn't apply anymore because party to a crime supersedes it. I'm not going to divine the meaning of their words. They're going to need to ask the question in a different way, but that's, I think what they're struggling with is that maybe with one defendant, to your point, like maybe manslaughter here, but not the other. So for that one defendant, is it both counts? But wait a minute, if it's in their mind clear that there is a malice murder, does party to a crime then overcome that manslaughter in that one, for that one defendant?
That part's just a guess. But
Yep, same. Okay. Mr. Rowe, I'm circling back now as promised. Any further thoughts on what to do with either of the questions?
Judge, I tend to agree with the court. We got to clean it up anyway. I think it's best to deal with it on the front end and go ahead and clear it up versus waiting until the inconsistent verdict comes.
I don't know that we are headed toward an inconsistent verdict. I think that if the jury's instructed, and kind of going back to your point, I think that we should keep it simple. And what the court told them is the best way, each defendant as to each count. I think if we just keep it that way, then we're not injecting any information into the jury room that they may get confused. I'm worried about.
Well, they are confused. We're at a point of confusion now. I don't want to make it worse. It'd be great to make it better.
And we don't know what unintended consequences, the more we say and start, throwing out legal, it's like we're going to the end of the chapter in the book and we're telling them what's going to happen at the end of the book instead of letting them work through the chapter of the book.
I too don't know that there will be an inconsistent verdict, but what do you think the answer is if they come back for, we'll just say Mr. Parks, it could be either or both of these defendants. For Mr. Parks, they say count 1, voluntary manslaughter, count 2, felony murder. How do you navigate that? And now Mr. Rowe saying, wait, it can't be both. And so they found that the malice was reduced to voluntary manslaughter because of some serious provocation. And so that malice, that intent, you got your aggravated assault, and maybe they're not inconsistent because the intent to shoot someone, aggravated assault, to commit that, to frighten them, scare them, use a deadly weapon, that's not the same as the intent to kill. And so maybe a jury could say voluntary to count 1, but that aggravated assault, 100% intentional. There wasn't this passion. I don't know how they do that because the aggravated assault is what killed our victim in this case. So back to my question, what do you do with a verdict that is guilty of voluntary manslaughter on count 1, felony murder on count 2? Do you view that as a consistent verdict, or that's one where we're going to have to do post-verdict surgery, which in some ways is even scarier than answering the question of saying, if you find for a defendant voluntary manslaughter on either count 1 or 2, the other count would be voluntary. That's what I would limit us to. Words to that effect.
I'm in favor of not trying to fix a problem before it is a problem, because I honestly think the more that we say to this, it may head us down a path of unintended consequences.
Okay.
They may say, okay, well, that's our answer to this defendant, so therefore it must be the
that's a sign that it's 5. They want to come back tomorrow morning. We'll talk about what that means in a moment for you, Mr. Rowe. But that would give the 3 sides a chance to think about this more, because the jurors can't talk about this question of voluntary manslaughter until tomorrow morning when they're back. And we could regroup and I could take everyone's pulse again with people having had a chance to research it if they want to research it, rather than we force an issue. Although I'll tell you my inclination, I'll think about it too. My inclination is that I tell the jury as to the count 1 or 2, if you find manslaughter for one, it would be manslaughter for the other. Now, if that's legally incorrect, tell me, and I wouldn't never say that then. But if that's legally correct, I don't think we are causing more problems than we are fixing by answering their question, because that's their question. If we found manslaughter for one, is it necessarily manslaughter for the other? Not defendants, but for those 2 counts. And I'd word it that way. So if we find manslaughter for count 1 or 2, does that mean for that defendant, it's manslaughter for the other of those 2 counts? I think the answer is yes. And to Mr. Menendez's point, I think Mr. Rowe said the same. I'm all for answering a question when it's asked, if it's legally, if there's a clear legal answer and there's not some obvious legal reason not to do it. Now, sometimes there's a clear factual answer. What did that witness say? But that's not our job to tell them that. This is not an evidentiary question. It's a legal question that they're struggling with. That's what I'm leaning towards, but why don't we think about it over the evening? Tomorrow at 9 o'clock, there will be a very large number of lawyers and spectators in here and a bunch of cameras. I have a hearing that will last all morning, but we won't start it right at 9 because we'll need to talk first. But whoever's here for Team Parks needs to be here a little before 9. And Mr. Menendez, you spent another day with us here. I don't know what you're doing with the rest of your docket. I'll need one of you here a little before 9. And I'll let the gathered groups know that we've got to knock this out first. And we'll get an answer to the jury, and then deliberations will continue. And we'll just have to interrupt this other hearing if there's another question or a verdict. I'll be out here the whole time. That hearing will go all morning. So that's where we are. Tell me what your plan is for tomorrow, Mr. Rowe.
Attorney Felicia Rowe will be here from 9.
It's a familiar name. Okay. She'll cover for you while you are taking care of what you need to.
Right, and I should be here around that.
Okay. And you talk with Mr. Parks about that?
Yes.
Good. You'll be in good hands, Mr. Parks, and you see what we're dealing with now. It's important stuff, but it's not getting up in front of the jury and doing this and that. It's just a little legal thinking about questions that come up. Okay. Anything else, Mr. Rowe, from you?
Okay.
Mr. Menendez, anything else?
Yes, Judge, I would want to ask them for some more context or clarity about the second question. You know, we all use words differently in different scenarios and with different backgrounds. Does party to a crime supersede manslaughter? I find that incomprehensible right now, and I would want to know what they mean by that before I answer it.
Me too. So what's going to happen in a moment, but I'm going to hear from Mr. Griner, see if there's any last point he wants to make, is well, we're going to check on them, but the jurors are going to want to go soon. When they want to go, I'm actually bringing them out, and I'll give them the usual instruction. Don't talk about the case. Stay out of doing any research tonight. I'll explain that we will have an answer for their question about count 1 or 2 tomorrow. An answer may be, figure it out yourselves. They're going to need to ask in a different way what their question is about party to a crime superseding manslaughter. I'm not going to invite discussion. That's not how we handle jury questions, but that'll put them on notice to, in the morning, compose that question in a different way. If you want to check with them, if they're going to stay for 5 more minutes, I'm going to write, I don't understand your question on the back of the party to a crime. They may choose to stay long enough to phrase it in a different way. Mr. Griner, any objection to me sending back to the jury, I don't understand this question, sorry, to does party to a crime supersede manslaughter?
I don't have an objection to that.
Mr. Menendez?
No objection, Your Honor, thank you.
Mr. Rowe?
No objection.
All right. And just let us know if they want to clear that up before they go, and we'll stay right here.
Judge, tomorrow morning I have a calendar call, another courtroom. It's scheduled for 9:30. I don't think it's going to be an issue. I just wanted the court to know.
Great. What number is it that we have on our little card? Is it your number or is it Ms. Porter's?
You have my work cell number.
Okay. So if we call that at 9:35, because that's when something comes up, will you be able to dispatch someone else here, or should we get Ms. Porter's number?
Either I or Ms. Porter will be here. I'd like for the court to have Ms. Porter's number as well, if that's possible. I know you only do 3 calls, but.
It turns out I've done 0 calls today. Ms. Nelson has done them all, but as a general policy, we'd like one number per team. But if you need to be somewhere else, we just need to know how to reach Ms. Porter. If you'll send your number to Ms. Nelson, she'll have that and can give you a shout. Or Ms. Nelson may bring you the card right now for you to write it on. Ms. Porter, if you'd come on over here.
I have my business card, is that okay?
She'd prefer to have it all in one place rather than more paperwork, which we fill her up with.
Thank you.
They're ready to go.
Okay. They're ready to go, but they wrote this on what would be juror question 5 for us to think about over the evening. Party to a crime and mere presence. If we choose manslaughter instead of murder, does that still indicate they are party to a crime and mere presence?
Yeah, I had the same reaction as before.
So think about it over the evening. What I would likely say in response to this, rather than make them write it again, is all the principles of law set forth, words to this effect, in the jury charge that you have apply to the offenses, including voluntary manslaughter. Because I think what they're wrestling with, wait a minute, if it's voluntary, do we think about mere presence or party to a crime? And the answer is yes.
Yeah, would the court mind just reading it one more time?
I wouldn't mind. Party to crime and mere presence. Dash. If we choose manslaughter instead of murder, does that still indicate they are party to a crime and mere presence?
I think the court's response is proper.
I like that, but we're not going to respond to either of these questions right now. So they're ready to go. Mr. Griner, are you okay if we bring the jurors out so I can give them parting instructions for this evening?
Yes, Your Honor.
Mr. Monetis,
Sorry, Your Honor.
you okay if I bring the jurors out?
Yes, Judge.
Okay. And Mr. Rowe.
That's fine.
Let's bring the alternate out as well, and we'll talk about his schedule for tomorrow. Thank you. No, you can sit in the jury box. You can be with your compadres. Is that a Braves hat?
Yes.
You heard about the first game.
No.
They lost the first game. Sale is pitching the second game, though. You do have to win it. So, I mean, you personally don't, but. Thank you, Deputy Gordon. Ladies and gentlemen, I want to thank you for your work today. It sounds like you're not done, and rather than staying later today, which we can accommodate if that's what you wanted to do, you want to come back tomorrow. You all need to be here at the time you agree. We can say 9 o'clock, but if traffic patterns and the haze coming from Conyers means 10 is better, you just need to tell me when we should expect you all so we know when to start calling if it's reached time X and you're not here. Have you all discussed when you want to start tomorrow? When is that? 9, the usual. Why not? Then you know where to report, 9 a.m. there. Deputy Gordon will, return your electronic devices in just a minute. We're going to take the evidence away. We'll return it once all 12 of you are in, and you can start again. I will have for you in the morning whatever answer I am legally authorized to give to the 2 questions. They're a little confusing, but I think I get it, but we can't have a back and forth. That's the awkward thing where like, hey, we could just sit down and talk. That's not how it works. And the lawyers and I have been ruminating, and they're going to get to ruminate overnight. And when we start in the morning, you can begin your deliberations, but we will cobble together whatever legally proper answer to both this question about if you decide manslaughter on either count 1 or 2, does that mean necessarily manslaughter for the other count? Reminder you to consider every count individually as to each defendant. And then you've clarified a bit your question about party to a crime and mere presence. And we'll work through that as well. So we'll get you answers. You may not love the answers because they may not be all that clear, but it'll be what we can give you. You have all day tomorrow as well. If there is a question or something, a verdict that requires you all to come out into court tomorrow before 1 o'clock, just want to alert you of a hearing tomorrow morning. There will be a lot of cameras in the courtroom because of what's going on. It has nothing to do with this case, but don't be startled if there's media here. They will not film you. They're going to have to stop what they're doing, and we'll get all these lawyers. These lawyers will be here. We'll get the other lawyers out of the way. That just may be a minute if you say, hey, we're done. Here's the verdict, or whatever it is. If we need to interact like this, you have to relocate some folks. But any media presence that is here has nothing to do with this case. It's a different matter. Okay. Last thing, how long does it take you to get down to the courthouse from wherever you would be if you didn't come here tomorrow? If you, yes, our alternate. If you went to work or stayed home tomorrow instead of coming down here, I'm trying to figure out if we need to make you sit around. You will remain the alternate and you will be pressed into service if need be. But if you tell me, hey, I could be here in 15 minutes, you don't need to be here tomorrow at 9. But if you say, yeah, it take about an hour if you call, I can get you here a lot sooner if you're in that other room. 30? Okay. And how would we reach you? You'd have your cell phone on you? Okay. Would you be at work or at home? Okay. And bright-eyed and bushy-tailed, we just need to call and you could be on down here in 30 minutes. Is that, I'm asking you, I'm not telling you. Okay. All right. All 13 of you, same rule, no outside research. Please don't talk to other people about this case. We're close to the end of the process, and so we need to maintain that information bubble. And that will apply to you as well, sir, while you are at home. We will call you when the case is, you'll get a phone call one way or the other. It'll be, come on down because we need to press you into service, or here's what happened. And then you will be released. But tomorrow is still jury service for you. We'll just let you do that from home. because right now we've got 12 sturdy, focused jurors and may not need to rely on you, okay? Okay, any logistical questions from anyone? No? All right, if you leave your notepads in there, once you go back in there, Deputy Gordon will get you your devices and we'll see you at 9 in the morning. Thank you.
All right, jurors.
All right, Mr. Griner, anything else from the state?
No, Your Honor.
Mr. Monetis, on behalf of Mr. Phillips,
No, Your Honor.
we're good with close for tomorrow?
Yes, Judge.
All right, Mr. Rowe, we will see Ms. Rowe tomorrow, a little before 9. You'll be back by 11-ish, whenever you can make it back.
Okay.
All right, and Mr. Parks is good with close?
Yes.
Okay, all right. We will talk tomorrow morning, ideally a little before 9, about answers to these 2 questions. Thank you.
Yes, Judge.